Concius. I'm a partner at Kiesel Law, which is in Beverly Hills, California. Just a little bit about me, not to toot my own horn, but just so you can understand where I'm coming at AI from the perspective. I'm a litigator. I've been doing this for a while, and I'm the president of the Los Angeles chapter of the Federal Bar Association. I'm on the merit selection panel, so I help vet the magistrate judges there. And my firm is made up of about a dozen lawyers. We do plaintiff side litigation, personal injury, mass torts, and class actions. I'm the head of the class action group. I sue large technology companies throughout the country. Right now, litigating against Meta in the Northern District. I'm in leadership for their obtaining medical information that they're not supposed to receive. Similar case against Google for the same thing. I've sued hospital chains over their leaking of medical data to third parties that they're not supposed to. And more excitingly, I've sued all the movie studios in town in Southern California and record labels, and I've represented the estates of Charles Bronson and the Temptations, who I just have to say, when they came dressed for their depositions, I told them to dress very nicely. They had their first name embroidered down the legs of their suits, which was really cool. And I told Otis, I'm going to get all the people at my firm to do the same, but I've yet to do that. We're a paperless office. That was a thing at our office. Before that was a thing all over the country. We do paperless trials. Everything is tech. We're early adopters. We love to try out new technology and to present on it across the country, whether it is to bar organizations nationally, locally, or a couple weeks we're going to the Hawaii Federal District Court to talk to the judges there about AI. AI is no different. We've tested all the products out there. Today, I'm going to be talking about AI, and I am specifically not talking about Filevine products. There are lots of other great lectures on that, but I want to make that clear. All the hazards that I'm about to talk about, I'm not talking about Filevine. I'm talking about LLMs, and for those of you that don't know, large language models. Many of these have paid and free subscriptions. So I have a paid version of ChatGPT. I pay for Perplexity. I pay for Google Gemini. I also use Claude on occasion. And Adobe has a product that we pay for at the firm that's pretty interesting too. LLMs, they're traded on vast amounts of text data, books, articles, websites, data sets. They process text into small pieces called tokens, which could be a word or less, or even just a character. And to generate an answer, and this is where lawyers and people get into trouble, the LLM predicts what the next token should be in a sequence, one after another, until it forms an answer. And I asked ChatGPT yesterday, I said, how should I explain what an LLM is? And it helpfully said, think of an LLM as a system that's read a huge library of text and then answers by predicting the next piece of language one chunk at a time based on what came before. When we're using systems that are outside of a thing like Filevine, outside of a closed system, and you're talking about LLMs, I want you always to remember that security needs to be top of mind, because we as lawyers and legal professionals have to keep client confidences. Always assume what you upload will be used to train other models and shared. I was at a conference a few weeks ago. I decided to sit in on the tech presentation, which was horrific. And somebody on the panel actually said he frequently uploads his clients' medical records to ChatGPT and then interacts with them. And somebody raised their hand and said, isn't that a violation of HIPAA? And he kind of explained it away. You know, lots of people look at your clients' medical records. It's no big deal. So remember, security is key. Regarding the future, I'm old enough to remember what it was like to do legal research in books, and I can't really see the audience, but I'm assuming somebody out there remembers that as well. So we had books, then there was online research, which was really cool. Lexis and Westlaw, that was great. The internet came alive. We had Google. AI is not Google. I was literally in court 2 weeks ago. We're litigating an issue where my adversary decided to use Harvey AI to summarize a bunch of contracts and then present a declaration to the court under his own name like he was a statistics expert. So in the first time in my 30-year career, I said, cool, I noticed my adversary's deposition. And I said, I want all your notes, I want all the inputs, I want all the settings for Harvey that you use to come to these conclusions. When we were arguing about this in front of the judge, the senior partner at this national law firm said, Harvey AI and AI, it's just like Google. That's what he said. And I'm looking at him thinking, this person has no idea what they're talking about. And at that conference that I went to a few weeks ago, the horrific one, somebody kept saying on the panel, who was very fond of AI, just keep thinking of AI as a first-year attorney. It's a first-year attorney. You need to, keep an eye on it. But just remember, treat it like a first-year attorney. AI is not a first-year attorney. So we need to embrace the future of technology, but we have to understand what exactly we're dealing with, and that's what I'm here. Law schools are now giving people, the first-year students, you get a free Westlaw subscription, a free Lexis subscription, obviously, because they're trying to get you to use it. And some law schools are now giving out free Harvey AI subscriptions. And I'm not here to bash Harvey, that's not the point. My point is that first-year students are now using this. So let's get to the PowerPoint. You're thinking, Jeff, you got these great screens. Let's see what's going on here. So the first thing on the screen I want to show you is, this is an opinion from the District of Arizona. And it's an order, and it says, on July 22, 2025, the court issued an order to show cause regarding plaintiff's opening brief. The court did so because the opening brief was replete with citation-related deficiencies, including those consistent with artificial intelligence-generated hallucinations. Now, I can assure you that on July 22, 2025, the plaintiff's attorney got a stomach ache and got very nauseous when they got this order. And what's really fascinating about this order that came out August is this. The court helpfully included a chart in its order, and in the chart, it really encapsulates problems that I want to just highlight about the use of an LLM for purposes of litigation or drafting something. So if you look at line 12, they cited this Hobbs case in their papers, and the court says the case does not exist. So that's just completely made up out of whole cloth, and in case you're the person in the room that doesn't know what a hallucination is, that's when the AI just decides to fill in the blanks and just make something up. So number 12, Hobbs, case does not exist. Well, that's bad. But there's different flavors of bad. Line 13, the Lingenfelter case. Here, the case exists, but the quoted language does not exist. And that's a problem that I've seen all the time as well. When I've done research trying to use AI for this, you go to a case, you're like, oh, this case sounds great for me. And then you start looking in the case, which does exist, but you can't find the quote. And then line 14, the Treviso case, the court says the case exists, but the proposition is incorrect. So now they've cited a case for an idea, but that idea is not in the case. Okay, so you're thinking, well, this is not good for the plaintiff's attorney. Well, that's true, but there's a further problem. Well, before we get to the further problem, the court said, therefore, of the 19 instances of the citations included in the brief, 5 to 7 of those exist and appear as quoted. Put another way, well over the majority of the citations provided to this court in plaintiff's opening brief were fabricated, misleading, or unsupported. Now, for those of us that are keeping track of what's going on in the AI space with lawyers, that's not too surprising. But what was interesting about this opinion is footnote 3. Footnote 3 says, defendant did not raise any of the above issues in the answering brief. Indeed, the only issue with any citation raised by defendant was plaintiff's citation to Revels. The Revels defendant noted that Revels relied on prior regs and therefore was inapposite. It is unclear to the court why defendant did not raise any of the deficiencies identified in the table above, particularly with respect to cases that simply did not exist. But the court focuses this order on plaintiff's counsel's conduct. So again, when the OSC was issued, the plaintiff's counsel definitely got a stomach ache. When this order was issued, defense counsel is now being taken to task for having not even figured out that there was so much imaginary stuff going on in the other brief. So I thought this was interesting. It was somewhat unique. Well, a couple weeks ago in California, my great state, the Court of Appeal issued an opinion. And in California, if you get sanctioned $1,000 or more, in most instances, you get reported to the state bar. So that's a goal when you go to court. Try not to get sanctioned for over $1,000. Here, the Court of Appeal, they helpfully sanctioned the council $10,000 and reported them to the state bar. Why did they do that? Well, the Court of Appeal said, in total, appellant's opening brief contains 23 case quotations, 21 of which are fabrications. Appellant's reply brief contains many more fabricated quotations, and both briefs are peppered with inaccurate citations that do not support the propositions for which they are cited. Again, that's a bad day for the plaintiff's attorney. But what's next? Defense counsel, as soon as they saw the order to show cause, thought, cool, I'm going to get some of this money that this person's going to get whacked for. Give me sanctions, award me sanctions. The Court of Appeal says we decline to order sanctions payable to opposing counsel. While we have no doubt that such sanctions would be appropriate, in the present case, respondents did not alert the court to the fabricated citations and appeared to have become aware of the issue only when the court issued its order to show cause. So why am I showing these two opinions? Because it's not enough that you don't use AI in your briefs or drafting, but as a lawyer, what you now have to do is to read very carefully the briefs that are coming into your office and use a tool. We have Lexis in my office. You can easily upload your opposing counsel's briefs and say, hey, check this brief out, see if it's okay. Westlaw has the same product. There are other ways to do it. If you don't subscribe to one of the fancy databases, do it yourself, but it has to be done. These cases look real, but they're not. And by the way, a couple weeks ago when they said, treat AI like a first-year lawyer, if I have a first-year lawyer at my firm who drafts a brief and it has 21 out of 23 cases that are made up in it, I have a different name for that person. It's not a first-year lawyer. That person's called unemployed. I mean, think about it. This is not a creative writing exercise, and that's what AI is doing. AI is just trying to come up with an answer to the question. It doesn't stop, and what it'll do, it'll say, okay, previous opinions have gone this way, therefore I'm going to fill in the blanks using the tokenization process I talked about. So again, it's not a first-year associate, and you as opposing counsel have to realize that this could very well be happening in the briefs, and the last thing you want when the court issues an order to show cause, whacking the other side, is a footnote saying, hey, what's with you? You didn't figure out that this stuff was made up? So there's two resources that I want to give to you folks. The first one is more interesting. The second one is very useful. There's a website that tracks AI hallucination cases. I'm going to show you an example of it on the next slide. And my friend's firm, Ropes & Gray, helpfully has a website that keeps track of all AI orders coming out of the courts, standing orders, and things like that. So quickly, I'll show you this. For the website that tracks AI hallucination cases, what's kind of interesting about this is two things. That you can sort it by date, you can sort it by country. And when I put this slide together, maybe last week or so, there were 250 opinions relating to hallucinations. Now, when I first started lecturing on this, for those of you in the know and you're kind of wondering, boy, this is really boring, Jeff, I know all this stuff, you may recall that there was a case called Avianca out of the Southern District of New York, and that was a little bit over 2 years ago. It made a lot of news because the attorneys there used ChatGPT, submitted their briefs, the court issues an order to show cause and says, hey, what the hell, hey, what the heck? There's a lot of cases in here that don't exist. And the plaintiff's attorney, to double down on their ignorance, went to ChatGPT and asked it and said, do these cases exist? And ChatGPT said yes. Fantastic. So that was the second AI opinion that came out, the hallucination cases. And my partner and I started lecturing on this stuff right after that opinion came out. And you would have thought that would have grabbed the news, people would have learned, but in fact they haven't. There's 250 cases at the time I did this slide. I checked before I came down this morning, there's now 270 cases. So in the last week and a half, there's been another 20 opinions about hallucinations in court filings. You don't want to get on this list, and it's a fun site to go to. For the Ropes & Gray website, assuming you're a litigator, what you need to do is you need to know in the district that you're in or in the area that you're in, what standing orders exist, what local rules exist, what are courts doing there. So I clicked on Utah. You can see that there is an opinion there. There's a magistrate, Judge Bennett, who issued an opinion relating to AI. It could be of interest. You can click on other states, for example, California. You can see that in the Central District, there is no local rule about the use of AI. However, there are judges, some, that have standing orders that say, hey, if you use AI, you have to put it in your declaration that you checked everything before you submitted this to me. So what you don't want to do is to use AI, even responsibly, and then get into trouble by not following what the judges are asking you to do. So I urge you to go to that website. Ethics. This is important. Obviously, we all want to act ethically in the legal profession, but there's a number of model rules that you should keep in mind, and there's probably more than this that you could violate if you decide to just submit a brief with creative writing in it, or otherwise. We have the duty of competence under 1.1. You have to have knowledge, skill, thoroughness, and preparation, and you have to know the benefits and risks of relevant technologies. And that's what I'm trying to get the word out on. Confidentiality. Again, don't upload medical records. Don't upload letters to your client. Don't upload documents that are covered by a protective order. You are really asking for trouble if you do that. And that's Rule 1.6. You have a duty of candor. You can't make a false statement of fact or law to a tribunal, and if you submit a creative writing brief from, bless you, ChatGPT, that's what you're going to have a problem under. 3.3. A duty of supervision. Look, you can't just say to the court, I use ChatGPT. No. Just like anybody else, you have a duty to supervise what is going on at the law firm, and that's very important. Then you get into some of the more interesting ones. When I first started doing these lectures, I asked ChatGPT, after I read the rules myself, and I said, what ethical rules should I keep in mind? It flagged for me the unauthorized practice of law. That's interesting. Well, you're not supposed to practice in a jurisdiction that you're not admitted. So I'm a California barred attorney, also New York and New Jersey. I get a call from somebody in Wyoming. They start asking me about something. I can't just go into ChatGPT and start looking up Wyoming law and give legal advice, because I'm now engaging in the unauthorized practice of law. And I could imagine a scenario where you get that call. And again, I'm a litigator, plaintiff side, civil litigation. Somebody calls me up, Wyoming, I need a will. No problem. Go to ChatGPT. I need a will. Use Wyoming law, draft the will. It will do that, without a doubt. But what are you doing? You're now violating 5.5. Misconduct. Obviously, we should try not to engage in dishonesty, fraud, or deceit, or misrepresentation. G is interesting. G was something that was flagged for me by ChatGPT, and I honestly hadn't thought about it. You shouldn't engage in something that is harassment or discrimination on the basis of a protected category. I know you're not supposed to do that. Let me make that clear. What I didn't understand is why is that an issue when it comes to AI? And it helpfully said to me, look, I'm trained on everything looking backwards. So that bakes into it a lot of things that were said from a long time ago that today would not be appropriate. So when you're relying on AI to do something, you have to keep in mind that those kind of things may very well enter into the picture as well. Duty of transparency. If you're going to use AI at your firm, probably should talk to your clients about it and let them know. So that's the ethical rules. Okay, great. Jeff, you told us how to get sanctioned. You told us how you're going to get whacked in an opinion. You told us how to have all these ethical problems. What can we do to stop that? So ChatGPT, Perplexity, many of the others, you can put in custom instructions. And what you want to do is you want to tell the AI and the LLMs really to be specific. And what I did is I originally had a custom instruction, which was, hey, look, I'm a leader of a bar organization. I'm a litigator. I don't want to have a problem. You got to tell me the truth. Don't hallucinate, please. And I put that into ChatGPT and I said, how can I make this better? And it made it much longer. So you'll see on the bottom left-hand corner, this is ChatGPT. You can click on settings. You can then go to personalization. And all of that text there in that box, some of which I'm about to read to you, was suggested to me by ChatGPT. And then it told me to go into the More About You box as well. So the custom instructions that ChatGPT told me to enter was 0 hallucinations. If you don't know or can't verify, say so. Go back one slide. If you don't know or can't verify, say so. Always distinguish fact from inference. Use primary sources whenever possible and cite them. For legal topics, use Blue Book format with pin sites and jurisdiction. For time-sensitive info, confirm the latest and include source and date checked. If I provide a document, cite only that unless I request outside research. Keep responses concise, structured, and skimmable. Lead with the answer, then sources. If you're going to do math, show me the math. And then in the About You box, I'm a litigation attorney. Accuracy and verifiability are paramount. Assume I need responses I can stand behind. By the way, my email address will come up at the end, jeff@kiesel.law. Feel free to email me at any point. Happy to send you anything that's here. We're all in this together. I want to keep you folks out of trouble, so let me know. Okay. Some real-world examples of how we use this at the firm. What you need to know is when I was in college a long time ago, I could not pass statistics and I dropped it. That's important. Why is that? Because we were brought in to try a case, a certified class action against a major airline with hundreds of millions of dollars. My partner and I are gearing up for trial. I'm assigned the task of taking the expert deposition, the other side's expert, and it's relating to this on the screen. This is a regression analysis. As soon as I saw this and I realized what I was going to have to accomplish, stomach ache, nausea, flashbacks, all sorts of bad stuff enter into my brain. I thought, but wait a second, I now have AI, I can use it to my advantage. So I took this file, I uploaded it to ChatGPT, and I simply asked, what is this? And I think the first try it's going to fail. I purposely left it in because that's not something that sometimes happens. I asked it to retry. It did. And then it helpfully started running through its analysis of it. It says the file you uploaded, Exhibit 2, with the name, is a statistical regression output table, likely from a statistical package, such as Excel or SPSS. Here's what it contains: dependent variables, R-squared, variance, ANOVA table, significance. Fantastic. I have no idea what any of that is, and that's really not helpful. So I said to ChatGPT, okay, cool. I said, please explain this to me like I'm in high school. And I'm not even sure that's my level of understanding of statistics, quite honestly. So it tries again. Got it. Here's a high school level explanation. This is the result of a regression analysis. Think of it like a math experiment where we're trying to see if certain factors like age, gender, or being a current employee help explain or predict some outcome, like a score survey answer or a job result. Then you'll see the little hand symbol, which is helpful because I'm in high school. Bottom line, the study tried to see if 10 factors could predict an outcome. Only 2 mattered a little, the rest didn't, and overall, the model doesn't explain much. Well, that's fine, except that's my expert's regression analysis, right? That's not helpful. So what you have to do is you then have to, it's a back and forth. This is not just putting something into Google, getting an answer, and then moving on. This is an iterative process. If you don't like the answer or it's leading you in a place that you don't want to go, push back, ask the next thing. So my follow-up prompt was, if I represent the plaintiff and want to cross-examine the other side's expert on this exhibit and want to support the findings in the exhibit, what should I ask? Because it just looked at the regression analysis and said, oh, this is bad. But no, I got to do something with this. And you can see how well I type. Great question. It always likes to pump me up. If you're representing the plaintiff and you want this exhibit, and then it kind of goes through, and it starts talking to me about how I can lend support to this exhibit. Drive home the significant findings. Reinforce what significance means. Tie it to your case theory. Strategy. Keep it tight. Great. At the end of ChatGPT, when you're interacting with it, as most LLMs do, there'll be follow-ups. In Perplexity, they're typically pre-done questions that you can click on. ChatGPT leads at the end. Do you want me to draft a scripted Q&A outline with leading questions phrased exactly as you'd use them in court, or more of a checklist you can adapt on the fly? Objection compound, but I said yes, which is what I like to do, because if it asks me a question, sure, why not? Go for it. Perfect. Here's a scripted Q&A. Establish the method, highlight the findings, reinforce what significant means, and now if it says neutralize the low R-squared argument. So now I'm getting somewhere. I'm thinking, oh, okay, great. Now this is helpful. I can really do something with this. Do you want to prepare a one-page cross cheat sheet? Okay, sure, why not? Here's a cheat sheet, the regression exhibit. This is just a reminder. A short redirect style closing argument, yes or no. You know, now it's thinking like this is going to be an episode of some sort of trial TV show. No, I don't want that. But what I do want is it'd be really helpful if I could have this as a Word document. And it does. And the cool part about ChatGPT now, it's much better than it was in the early part. You can get it to download a Word document. You can say, make this into an Excel file. You can tell it whatever output you want. Right now it's analyzing and thinking. I left this in here just to show you it's not instantaneous. And eventually it's going to come up. And there it is. And you can download it. And that's in Word. Okay, so we've now used ChatGPT to help us with a statistical expert thing. And as I told you, I'm litigating right now the issue of an attorney who just decided to bypass hiring an expert, upload all the documents, and then submit this analysis using Harvey AI. So the Federal Rules of Evidence, proposed Rule 707, is very interesting. Luckily for you, it's short, but it gets right to the point. When machine-generated evidence is offered without an expert witness and would be subject to Rule 702 if testified to by a witness, the court may admit it only if it satisfies the requirements of 702. For those of you that don't know, if you're in federal court under the Federal Rules of Evidence, if you want an expert testimony to come in, you have to prove certain things under Rule 702 for it to be admitted into evidence. And what this rule is now figuring out, people aren't going to use humans anymore to try to get evidence in. They're just going to throw it into an AI and then submit it in some form of a declaration. So this proposed rule is saying, well, if you're going to do that, it really should have the same gatekeeping that you would with a person. And the commentary says, when a machine draws inferences and makes predictions, there are concerns about the reliability of that process, akin to the reliability concerns about expert witnesses. It goes on. You have to think about the inputs. You have to think about the training data. And so it's not just a matter of it comes in. And that's, again, something that you have to think about. In my case, which is in California State Court, I use the proposed rule saying, look, I realize this is not applicable. It's also not an actual rule yet. It's a proposed rule. But I want the judge to start thinking that you have a gatekeeping function, and that function is not gone just because the other side decided to use AI as opposed to having a person in front of you testifying to it. Okay, how else can we use it? This is ChatGPT. This is the prompt I put in. I'm trying a personal injury case to a jury in California Superior Court. It's a rear-end accident. My client is the plaintiff and suffered physical injury and loss of income. What jury instructions should I consider using and list them specifically by CASI, title, and number? CASI are the California Form Jury Instructions. Let's say you're a first-year attorney. Partner comes running down the hallway. Hey, we're going to trial. I need to put together a list of jury instructions. Runs out, doesn't tell you how to do it. Okay, great. You put that in. So what's really interesting is it's given us a list of jury instructions. But what you have to keep in mind is it's trying to fill in blanks. I basically had 3 or 4 facts in that prompt, and ChatGPT gave me a list of Casey, great. However, it has on there, 4th one up from the bottom, comparative fault. I never said anything when hey, I need jury instructions that my client might have a problem. Aggravation of pre-existing condition, I never had that in my prompt. Causation, intervening events, I never said that there was an intervening cause. The more you give to the LLM, the better the output's gonna be, but as hopefully I've gotten through to everybody here, you can't just take what it gives you, put it on pleading paper, the way it works in California, run into the partner's office and then say done. This is the beginning of the process, certainly not the end. I then said, make that into a Word document. This used to be much cooler back in the day with previous versions of ChatGPT because you could see it actually create the thing right in front of you on the screen. Now it just analyzes it and says, here's a link. And that's it. You click it and you open it into Word. Other uses of AI that aren't in the slide deck that we use at the office. And these are all regarding publicly filed documents and not documents that have confidential stuff in it. Let's say you're opposing a motion, you brought a motion and you have a right to a reply. Copy in the moving papers, copy of the opposition papers. Say to the AI, I'm drafting the reply. Tell me what are the best points I should push on. Outline the arguments for me. For oral argument, ask it to play the role of the judge. Upload all the documents and say, I represent the plaintiff. What are the things that I should be most concerned about if you're the judge relying only on the papers? Many of the LLMs now you can actually talk to. There was a great South Park episode about that. But so what you can do is you can actually practice your oral argument skills. You can upload the documents and then talk to it and say to your phone, hey, you're the judge. Help me practice. What are the questions I need to answer? It's a great tool to use. Upload non-confidential documents, ask for summaries. We were involved in social media cases where we've sued all of the large platforms for personal injuries of kids committing suicide, eating disorders, things like that, using TikTok and Instagram and others. The court issued a ruling that was over 80 pages long when the other side tried to dismiss our case. And we uploaded it to 3 different LLMs and said, summarize this in 1 paragraph. And the purpose of that was perhaps first to see if it could do it. But what we could do is you could then take that and you can say, hey, put that in the words of a high schooler. That way you can then use that perhaps for a communication to your clients. And then you can let them know, good news. The court didn't dismiss the case. This is what it had to say. Letters. We have an associate in our office, she left voluntarily, and very proud of her vocabulary. She would draft documents or letters to clients that had just gigantic words in them. I have a pretty good vocabulary myself, and there were times where I had no idea what she was talking about. And finally I said to her, look, let's take your letter, take out the stuff that's confidential, stick it into ChatGPT, and say, can you simplify this? Can you put this in words that somebody can understand with only a college degree, a high school degree, no degree? And it was really eye-opening to this person how you could get the same point across by using much simpler words. Ask it to find source materials to research an issue. Put in something that you're mulling over. When I was dealing with this Harvey AI declaration thing, I uploaded the declaration. It was kind of fun. I had ChatGPT telling me the problems with Harvey AI and what are the points that I should be thinking of and how to approach it. I was asking it for links to give me the information that I could use for my briefs. For trials, we have asked it and uploaded jury questionnaires. And we've said, here are some jury questionnaires from previous trials, blank ones. This is the case that we're going to trial on. These are the facts. We represent the plaintiff. Help draft a jury questionnaire. We get it. Did we then print it out and submit it to the court? Absolutely not. However, we use that as a starting point. Filled out questionnaires on a trial. There's nothing better than when you're doing jury selection and staying up all night reading through 50 jury questionnaires that are 30 pages long and trying to figure out who'd be good for you. What you can now do is you can scan those, and assuming they're public in the jurisdiction that you're in, you can then ask the AI and say, look, if I want these specific answers to questions, or if I'm looking for these characteristics, which jurors should I be concentrating on? At my firm, when we're picking a jury, what we do is we have a team of lawyers and other staff back at the office. As soon as we get the jury list, they start scouring the internet to try to figure out what can we find on the people that are in our jury pool. You don't have to do that manually anymore. You can upload that list, again, if it's public, to Google Gemini, which is a great one to use, or ChatGPT, and you can say, look at social media postings, look on the internet, and try to tell me information about these people. Now, it's not going to work if the person on your jury's name is John Smith. However, if you got a guy like me with a ridiculous name on there, cool, you're going to find out lots of interesting stuff. Use that. Design demonstratives. Ask it to put together a drawing of a lumbar spine. Ask it to put together a demonstrative of we were just on a panel, and the fact pattern was somebody on a cruise ship, they have a diving contest, dives into the swimming pool on the ship, bonks his head on the bottom, now is paralyzed. We asked it to put a demonstrative together with that picture. Did it do it perfectly the first time around? Absolutely not. However, you can iterate with it, and you can say, I never told you that, or move the pool this way, or it never said 10 feet, no diving, you know, get rid of that from the slide. But you can get creative with it. And I guess the big idea is to use it for something that you really know about. If you like to cook and you have a favorite recipe, put into each one of the LLMs your favorite recipe and say, how do I make whatever? And see what it says in response. If you have a handful of ingredients, say I have these ingredients, put it in, say what can I make? If you're into sports, ask it questions. I'm a Jets fan. I basically ask, when do I stop watching? And, you know, that's easy. Normally I'm done before Halloween. Cool. But my daughter's a figure skater. She's been doing this for 20 years. You think I'd know how to read a score sheet by now? I don't. She's now an ice dancer on Team USA. I take her score sheet, I upload it, and I say, explain this to me. And then I ask her, my daughter, I say, hey, is this right? And she's always laughing and saying, yes, it is. I've asked it to code. I wear an Oura ring. I wear a continuous glucose monitor, even though I'm not a diabetic. I keep track of my blood pressure. I know I need other hobbies. But I've gone into the LLMs and I say, look, I have all this data. What can I do with it? It said, I'll write you a program. And it's doing a very good job of getting all the data together and then to present it to me as a chart. Early on in our medical litigation against hospitals, I asked it to write a program to find trackers on hospital websites. And it's not, again, it's iterative. The first time it said, there's nothing there. And I'd say, no, it's there. And it'd say, oh, let me adjust the code. And eventually it did. Cut and paste between the two. Put in a question into one, put the same question into another. Then put the answer of one into the other. Hey, I need a workout program. Cool, do this. The other one says the same thing. Cut and paste from Perplexity into ChatGPT. Say, my friend says to do this. What do you think? Oh, yeah, that's a good idea. Let me adjust it. Back and forth. Okay. I asked ChatGPT, I said, I'm giving a seminar on AI, justice, and the future of law, ethics, and innovation. Give me a one-sentence wrap-up. And it gave me this nonsense. As we stand in the intersection of AI, justice, and innovation. What is this, the end of a Star Trek episode? No, I don't want that. So at the end it says, would you like me to also give you a shorter, more conversational version? Yeah, cool, do that. Okay, so great, my input there is yes. Here's a more conversational closing. In the end, the future of law and justice depends on us. I'm not saying that. Do you want me to give you 2 to 3 alternative short closing or slightly different ones? Inspirational, pragmatic, provocative? Yeah, please. Pick any of the 3, they're all ridiculous. Provocative. The real question isn't whether AI will change the law. It's whether we will let it erode justice or insist it strengthen it. Okay, that's not helpful. Would you like to refine one of these into a punchier mic drop style ending that you could deliver and then simply walk off the stage? Yeah, please. AI will transform the law, but only we can decide if it serves power or if it serves justice. So that's it. We have a few minutes remaining. If anybody has any questions, feel free. Again, that's me. Please reach out, send me emails. Thank you.